Hi legal writing students, we're almost to the end of our little video marathon here, and the last topic we need to cover is secondary sources. This is covering pages 25 to 30 in your legal research workbook, and we're going to talk about why you would want to use secondary sources and some particular types of secondary sources. Why would you want to use secondary sources? Before we discuss that secondary sources really shouldn't be cited in a brief that you would submit to the court because it's persuasive only. It's not going to be binding law. I mean, you could cite it if really there's nothing else to cite, but it's preferable really to cite to primary authority, statutes, case law, etc. So if that's the case, why do we even bother with secondary sources? Well, we bother with them because they can really save you time, particularly if you're not familiar with an area of the law. The secondary source will summarize and explain the law instead of having to read 10, 12 cases to understand what's going on in an area of law. You could maybe read a paragraph or two that then has footnotes to those cases. Secondary sources can help you find more search terms, legal terms of art. If you remember from an earlier video, we had the example of the constructive possession case where our defendant was accused of possessing drugs that were located underneath the bushes in a common area. The word constructive possession, you wouldn't know that from normal language. It's a legal term, and you would have to find that out by looking at a secondary source that talks about drug possession and what possession means. And then you could come up with that term, constructive possession. Okay, secondary sources give you an overview of the topic. Sometimes they help you think of issues that you didn't really think of before. They lead to primary authority, so they can help you find the statutes and cases, regulations that you need. So secondary sources are always a great place to start unless you're real familiar with that area of law. All right, so now we're going to talk about the different types of secondary sources. When you're on Lexis and Westlaw, you can search you can search everything at once, but you can search all secondary authority at once. So you're kind of getting a little bit of everything thrown at you, and it's good to know what these different things are when you get your results. Also, it's good to know what these things are because in some cases you might want to go directly to a legal encyclopedia to start with, or directly to a practice book, and maybe look at the table of contents and do that as another way of searching on Lexis or Westlaw. Okay, so we have, this is a little diagram that shows our secondary sources from general to specific. Encyclopedias are the most general, followed by treatises and practice books, then ALR articles, and then law reviews are the most specific of all. But let's talk about what these different things are. A legal encyclopedia you could think of as, similar to an encyclopedia that you used maybe in grade school or something to write a report. They give you a broad overview of the topic. They tend to be very large sets. If you look at them on the shelf, they cover many legal topics. They cite to primary and secondary authority. They cite to the statutes and case law that are relevant. Legal encyclopedias, just like Encyclopedia Britannica, are arranged alphabetically by topic. What we have here is a picture of American jurisprudence. This is a large national legal encyclopedia. It covers the law in all 50 states and federal. So it attempts to cover, the law nationally. It covers many different topics. Another national legal encyclopedia is Corpus Juris Secundum. And I should say that American jurisprudence is available on Lexis and Westlaw, but I believe CJS is only available on Westlaw. For Ohio, there is something called Ohio jurisprudence. It's a legal encyclopedia specific to Ohio law. So if you want a secondary source for a certain topic in Ohio, there might be a practice book available, such as tort law or criminal law. There's a practice book. There's Ohio civil procedure practice books, but there's not a practice book on other topics, like, say, contracts in Ohio. However, contract law in Ohio is covered in Ohio jurisprudence. So Ohio jurisprudence is often a good place to start. And it cites to your cases and statutes, and it helps you find primary authority, as well as giving you an overview of the law. This is a little section from American jurisprudence, just to show you what it looks like on Lexis here. And you see that the section has some text and it has footnotes, and the footnotes cite to a bunch of cases. So treatises and practice books, I sort of alluded to those before. What those are is they're going to focus on a particular legal topic, such as maybe contracts, torts, criminal law, civil procedure, property, etc. And there's treatises and practice books for both national in scope, and for specific states, such as Ohio. And I will say that some states have more practice books available than others. Ohio happens to have a lot of practice books available. So some examples of treatises. Wright and Miller is a large treatise on federal practice and procedure. Mueller and Kirkpatrick is a treatise on federal evidence, also very large. And there's Larson on employment discrimination. These are just examples. There's many more for whatever topic of law you could think of. As I mentioned before, practice books can be jurisdiction specific. And here's an example here, Ernst Tort Law, which focuses just on tort law in Ohio. Restatements. Restatements are really a special kind of secondary source. Why restatements stand out from the rest of the secondary sources, that it's the one thing that it's kind of okay to cite it in a brief, or judges maybe cite these things a lot in a court opinion, because what they are is a common law rules or majority consensus in United States jurisdiction on certain subjects, such as, contracts, property, or torts. That, it covers certain subjects. Agency, I believe there's a restatement of agency, a restatement of trust. These are considered authoritative because they try and come to a consensus of the law, and they're made by a whole committee of prominent professors and lawyers and whatnot. So restatements can be pretty persuasive as far as secondary sources go. Okay, and restatements are both on Lexis and Westlaw. Here's an example of a restatement. Here we have restatement of torts, and you could see this covers various topics, elements of a cause of action for negligence. It kind of sets out the black letter law, if you will. And then if you open up a particular section, there's the restatement, the text of the restatement, as well as cases by jurisdiction. American law reports. American law reports cover all 50 states and federal. There's ALR reports have articles on very narrow, specific questions of law. And it doesn't cover every single topic, even though it's really huge and covers a lot of topics. But if you happen to find an ALR article on point, it can really help you a lot, particularly for federal issues. And I think also for state issues, if you're researching multiple states, multiple jurisdictions, or even all 50 states, ALR can give you a really good start on a project like that. One thing you should know about a couple things you should know about ALR, both on Lexis and Westlaw. There is a table of cases at the beginning of your ALR article that's organized by jurisdiction. So here I'm going to show you what that is. So this is an article about burglary, breaking, or entering of a motor vehicle. So here we have a table of contents, an article outline, and we get down to table of cases. So you see there's a couple federal jurisdictions listed at the top, and this is going to be mostly state jurisdictions on this particular issue. So we see it starts with Alabama and lists a bunch of cases for Alabama and all the way down. And text underneath that, there's going to be text discussions that cite to all your cases in the 50 states and possibly federal. The next type of secondary source I'm going to talk about is a law review and journal articles. So what's the difference? Law reviews are published by law schools, and journals are written by commercial publishers. Law reviews and journal articles tend to give in-depth treatment of very focused issues. Journals maybe tend to be more practical. So law review and journal articles might help you. Sometimes in practice, particularly maybe if you're doing something at the state level, it might not, but they're worth looking at. So, and that's just, I should say, maybe that's just my opinion too. So the most persuasive to the least persuasive, and this is roughly, and do remember too, secondary sources are only persuasive, not binding on a court. The most persuasive is restatements. Treatises and law reviews might be persuasive to a judge, possibly depending on who wrote them. Then practice books than your ALR articles and encyclopedias. It's important for me to emphasize to you that all these different types, secondary sources, they provide citations to primary sources. I think I've said that about 50 million times, but I'll say it for 50 million and one times. It gives you citations to your statutes, cases. So it really gives you a good start for your research. So in our next videos, we are going to see how you can find secondary sources on Lexis and Westlaw.